morning.
Good morning.
May it please the court, my name is Paul Kutcher. I'm the attorney for the appellant, Heavenly Air Conditioning and Heating, Inc. in this case.
Okay.
I request to reserve 5 minutes of my time for rebuttal.
You got it.
This case, this appeal involves the entry of a final judgment on the pleadings based on the appellant's second amended third-party complaint. The central issue in this case is whether the allegations in the second amended third-party complaint that define the source of the settlement proceeds that are to be dispersed for Heavenly Air's benefit were to come from construction loan proceeds that were obtained by Trinity are contradicted by the exhibits that are attached to the complaint.
Doesn't the addendum to the settlement agreement specifically take the Trenum firm out of the decision-making loop on the disbursement?
I'm sorry?
The addendum to the settlement agreement?
The second addendum?
Yes.
You're asking whether it...
It seems to me that it specifically takes the decision-making for disbursement away from Trenum and puts it into the hands of Trinity.
Well, what I see that the second addendum does is it identifies a different party as the party that's responsible for disbursement. It does not address the source. If you recall, in the original the original escrow agreement, the source of the settlement funds is not defined. However, if you look at the settlement statement, the loan settlement statement, which is attached as Exhibit G, it is apparent that the purpose for which the agreement is entered into is to effectuate the terms of the construction flow agreement that's amongst the principal parties, those principal parties at that point being the owner, Trinity Town Center LLP, the general contractor, South Capital Construction, Inc., and my client, Heavenly Air, who was a subcontractor.
Help me understand why the source is important, because the way I look at this is, following up on Judge Black's point, is it looks like the addendum was specifically created to take Trenum out of the decision-making process, taking away the power for it to disperse anything from the escrow account. And you seem to make a distinction between the source of the funds as somehow material, because I look at this as it doesn't matter what the source of the funds, everything that came into the escrow account, no longer did Trenum have the ability to disperse or have the power to disperse. Only Trinity did, and that's what the amendment was all about.
And if that were the purpose of the amendment, then the amendment would be, the purpose of the amendment would be specifically to release Trenum from any obligations of the escrow agent, and that's not addressed in any of the addendums.
But an escrow agent has obligations separate and apart from the dispersal, which was taken away from them. They have other obligations, so releasing them wouldn't, if you release an escrow agent from anything, then you don't have an escrow agent, because they do have certain responsibilities.
Right, and the responsibilities in this case would be that the escrow agent would still maintain the duty of a fiduciary duty that's owed to each of the principal parties. The principal parties, again, are Heavenly Air.
I'm with you on that, but walk me through why the source of funds is so important.
Because the source of funds, the problem we have here is the construction flow agreement is the determinative source from which we can identify what the intention of the principal parties was concerning the source of the funds.
So then is it your position that the addendum gave Trenum the power to disperse certain funds from a certain source, but not other funds from another source?
My position is that since the addendum doesn't address the intention of the parties of the principal agreement concerning the source, that if in fact that as is alleged in the complaint, that the source was to be the construction construction loan funds, then the obligation of Trenum would have been to take the construction loan funds and do one of two things in regard to the loan settlement statement. Either allocate a specific amount that is to be distributed or dispersed to Trinity for the purposes of allowing Trinity then to disperse those funds to Heavenly Air in accordance with the terms of the escrow agreement, or if that were the case, if in fact the intention were to have Trinity responsible for a direct payment to Heavenly Air, that reference would be in the context of a payment outside of closing on the loan settlement statement, neither of which appear.
Was there a lawsuit filed against Trinity because they breached the agreement to pay Heavenly?
There was no lawsuit filed by my client against Trinity. And the reason is because Trinity ultimately filed for bankruptcy after Sunfield Homes had filed a foreclosure action against Trinity based upon Trinity's failure to pay back the loan.
So you're using the word intent, that the escrow agent should read into the word intent and divine this duty to ensure that Heavenly was paid somehow by someone or itself, even though the language doesn't give it the power or the authority to pay under the contract.
I think that what needs to be done, that what didn't occur here, was Trenum had an obligation to find out what the terms of the construction flow agreement amongst the principal parties was, so it could ascertain what the intention was with regard to the source of the
And the court
proceeds.
specifically did not consider the construction flow agreement.
It
making its
appears as if
ruling.
the construction flow agreement was not considered at all. Rather, what Trinity, or what Trenum had done is looked at the escrow agreement as the definitive source from which it derived any obligations to the principal parties.
The court found that the construction flow agreement was not attached to the third-party complaint and was not incorporated into the settlement documents.
Well, and the first part I agree with. It's not
You can't
attached.
get to where you want to get to without considering the construction flow agreement, which is the court, and that's what you're claiming is the error here.
The error is that the construction flow agreement is an operative part of the agreement because it's incorporated. If you look at the fourth whereas clause of the escrow agreement and the seventh whereas clause of the escrow agreement, now naturally, generally, whereas clauses are not a part of the operative terms of an agreement, and that's referenced in the Johnson case that I cited in my brief. However, where the whereas clauses are specifically incorporated by reference into the terms of the agreement, they become a part of the agreement. And in this case, if you look at paragraph 1 of the escrow agreement, it expressly incorporates by reference each of the recitals. Therefore, the scope of the escrow agreement is directly related to the settlement rights and obligations of the principal parties to the primary agreement, that being the construction flow agreement.
Understood.
Okay? So the essence here is the basic fundamentals of escrow agreements involve two agreements. One is a primary agreement amongst the principal parties, and two is an agency agreement in which the principal parties engage the services of a third party, that being the escrow agent, to essentially effectuate the terms of the primary agreement so as to allow disbursement of funds to occur in accordance with the intention of the parties to the primary agreement.
Do you have a case that talks about the escrow agreement? Escrow agent needs to divine the intent of the parties?
And that's where we are here. That's why this case is important. Because if you look at Seligman,
I mean, anyone could make that argument.
I understand
Intent's
that.
always to be considered by an escrow agent. No one would want that job, because no one can divine intent out of a black and white document that says you don't have the power or the authority to do X, Y, or Z, and you say, yeah, but if you look at the intent, you do have the power. That's where I'm kind of getting lost in the shuffle here.
Well, if you look at the escrow agreement is contingent upon the terms of the construction flow agreement. And to take this one step further, although the construction flow agreement is not attached as an exhibit, it is incorporated into the agreement. So that means in order to ascertain what the intention of the principal parties is, at this point in time, you'd have to go outside the pleadings in order to make the determination what the intention of the parties was. And if you do so, then the case is not a case for which a judgment on the pleadings can be entered.
But you're not supposed to go outside the pleadings.
Pardon me?
You're not supposed to go outside the pleadings. The judge looks
Correct.
at the pleadings, and the pleadings negate the claim you're referring to.
But the judge looked at it from the standpoint, and this is a de novo review, I understand that, but I understand your question as well. The judge looked at this and said that the construction flow agreement was not incorporated into the escrow agreement, and that is not the case. When you look at paragraph 1, those terms of the construction flow agreement are expressly incorporated into the escrow agreement. If they're expressly incorporated into the escrow agreement, that triggers an obligation on the part of the escrow agent to learn specifically what the rights and obligations are of the parties. And quite frankly, what I was getting at before is this argument was raised in the court below. And one of the things that that I found interesting with the argument is that although the Seligman case references a legal obligation on part of the escrow agent to know the provisions and conditions of the principal agreement concerning the escrow property and to exercise reasonable skill and ordinary diligence in holding and delivering possession of the escrowed property, the argument that was advanced below was, well, that's only if there's no express agreement. Because the language in Seligman says in absence of an express agreement, those two requirements of the escrow agent come into effect by operation of law. Now, I have a problem with that when I juxtapose that concept with the concept that's referenced in Watkins that says that the escrow agent has a duty to disclose material facts. So the question then becomes, okay, if there is a written agreement and the exception exists that says because there's a written agreement, you don't have to worry about knowing of the provisions and worry about exercising reasonable skill and diligence in distributing the escrowed property, then how would the escrow agent be able to ascertain what the material facts were that they had an obligation to disclose to the principal parties in the event that something occurred, such as occurred here, by which when the escrow agent came into possession of the funds, the escrow agent was not authorized by the bank to disperse the proceeds in a manner that was consistent with the terms of the escrow agreement. Do you understand what I'm saying here?
Well, unfortunately, we get to ask the questions.
I understand that.
You have about 7 minutes left if you want to keep going or you want to save your full 5.
Well, the issue that I want to emphasize again is the source of the settlement proceeds. Now, we know that the source of the settlement proceeds would have to come from the settlement funds, I should say, because settlement funds is a defined term within the scope of the escrow agreement. The settlement funds can't come from the escrow agent because there's no debtor-creditor relationship between the escrow agent and any of the principals, in this case, Heavenly Air. So if that's the case, then the question is there an inference that arises that the settlement funds is intended to be some source other than Trenum? And the answer is yes. So where's that source? The original agreement says that Trinity is supposed to deliver the funds to Trenum. The secondary agreement, the addendum says, oh, no, Trinity is supposed to deliver the funds to Heavenly Air. All right, but what are the settlement funds?
Well, let me ask you a question. All the funds were dispersed.
Yes.
Everybody got paid in full except your client?
No.
So everybody got a haircut?
Some people got nothing, some people got paid, and some people took a haircut.
Okay. And your client received a mortgage for some portion of what they were owed?
A portion, yes, and that's another thing with regard to the definition of settlement funds. If you look at the definition of settlement funds in the context of the original escrow agreement, it's just settlement funds, and it references a number. But settlement funds become something else.
Are there any other lawsuits pending against Trenum other than your client's case?
No,
So
not
the
to my
people that
knowledge.
took nothing, they didn't sue Trenum for violation of fiduciary duty?
No, and I sued Trenum and Sunfield.
Right. Okay, I got you.
Okay? The reason that we're not suing Trinity is because it's useless.
You're right, you're 5. You want to save it? Or
I'll
keep
save it.
going? Okay,
Thank you.
thanks.
May it please the court. Good morning. Marie Tomasi from Trenum Law.
Who are you with?
Yeah, it's a
You
mystery.
said Trenum, okay.
I am with
Sorry.
Trenum, Your Honor. Actually, to answer your last question first, there are no other lawsuits pending against Trenum arising out of this escrow agreement or out of the Trinity situation, shall we say. And it's unfortunate, and I don't mean any disparagement, but I think counsel has admitted the fact of why Trenum is sued is because we're not in bankruptcy. I mean, it's, if you can't recover.
Well, bankruptcy obviously put a kink in the works as far as the source of funds go. That was the end of that one.
If you can't recover.
And I think his argument deals with the issue of intent, that you could divine intent
Right.
by reading the documents, even if there's an attachment that's missing, it's incorporated by reference. Let's see what you have to say about that.
Certainly, Your Honor. In fact, the source of the funds is irrelevant, but first let me address the contention even that the construction flow-through agreement is incorporated by reference. It is not. If you look at the recitals, all the recitals that counsel relies on the first one says, these three principal parties, Trinity, Sunfield, and Heavenly, are party to a certain construction flow-through agreement. Semicolon, next recital, not related to that agreement. Then in the incorporation, the recital that incorporates all the wherefore clauses says that they are incorporated, that the whereas clauses are incorporated. So nothing says the construction agreement, flow-through agreement, identified in that whereas as an agreement between the three principal parties, but nothing says that actual agreement is part and parcel of the settlement agreement. It's not attached, it's not identified as an exhibit, it doesn't even say it is incorporated herein as a part of this agreement. So we wouldn't even agree that it's appropriate to consider what that agreement says. Trenum was not a party to that agreement either. However, let's just assume all of that. Let's assume counsel's reading is fine. The source of the funds doesn't matter because the claim against Trenum was breach of contract for failure to pay Heavenly out of the escrowed funds or to ensure that Heavenly got paid. But addendum 1, the first addendum to the escrow agreement, expressly takes away Trenum's ability to pay Heavenly. Whether Trenum wanted Heavenly to be paid, thought they should be paid, it doesn't matter. It's not Trenum's money that's in the escrow fund, and it's not our power or authority or duty even to pay it to Heavenly after addendum, the first addendum, where all of that was transferred to Trinity. So Trinity was obligated to do those things. The settlement agreement also, when it references settlement funds, references a transaction or series of transactions as the source of the funds, belying the idea that there was one particular source of funds defined in this agreement. But again, it just doesn't matter. It's really not the source of funds that was at issue. The breach of contract claim was not stated as premised on Trenum somehow breaching the contract related to the source of funds, although I don't know how you could do that. An escrow agent doesn't create the funds, they just hold the funds. But the bottom line question is, as pled, where Heavenly said that Trenum breached the contract by failing to pay or to ensure that Heavenly was paid, and that duty, obligation, power was taken away.
I have a question that's kind of related to the argument that Trenum was a party to the settlement agreement
Yes, sir.
because they signed it. He's asking for attorney fees as a prevailing party, that there's an attorney fee provision in the settlement agreement, but you're asking for attorney fees not pursuant to the settlement agreement, which you just said Trenum was a party to, but pursuant to the rule that requires some sort of frivolous action to be awarded attorney fees. Is there a discrepancy there, or am I just looking into the wrong rabbit hole?
No, I don't think there's necessarily a discrepancy. I did not, I personally, since I wrote the motion for fees, I did not know the propriety of an escrow agent asking for fees from a principal party, and so we did not assert a contract-based claim. Also,
I mean, you could have in the alternative.
I think we could have,
That was
but we
my-
chose not to, Your Honor, and we just asserted it under the one.
Well, I don't know if admitting you're a party to the escrow, to the settlement agreement as an escrow agent advances your argument or it subtracts from it. I hadn't analyzed that thought, so we can just let that go then.
Yeah, I'm not sure that it would have made a difference, but we just didn't want to
I got it.
pursue that. and
Okay.
Just a choice.
Fair enough.
If the court has no further questions, then I would simply wrap up by saying that our trial judge, Judge Sharp-Bird, did a very careful analysis without going outside of the pleadings. She explained her rationale very clearly. I know this court has de novo review, but I would suggest also that Judge Sharp-Bird did a very good analysis that should be affirmed. Judgment on the pleadings was correct because Trenum simply had no power and no duty to direct or ensure payment to Heavenly.
All right.
Thank you.
Thank you. Mr. Kutcher, you've got your full 5 left.
Thank you, Your Honor. May I respond initially to the claim that the recitals do not reference any intention with regard to the settlement of the claims based upon the construction flow agreement. If you look at paragraph number 7 of the initial escrow agreement, it says, whereas Trinity South Capital and Heavenly Air wish to settle and compromise any and all lawsuits, proceedings, claims, and/or disputes between and among them, known or unknown, past, present, and/or future, from the beginning of time until the signing of this settlement agreement, which relate in any way to the matters related in these recitals without admitting liability as to said dispute. That seems to be pretty consistent with the idea that the purpose for which this settlement, the escrow agreement is entered into, is to effectuate the terms of the construction flow agreement. So it is incorporated by reference by virtue of paragraph 1 of the escrow agreement that incorporates by reference all terms of the recitals into the operative terms of the settlement agreement.
Did you want to respond to the question I asked her about, is the escrow agent a party to the settlement agreement for purposes of the attorney fee provision, or was she limited to asking for attorney fees under the rule, and you're limited to asking for prevailing party fees under the contract?
No, she's a party, the terms are party to the contract, all right? And they are...
So in other words, if you're entitled to fees, she would be entitled to fees under a reciprocity view.
If in fact she raised that as the basis upon which she's asserting a claim for attorney's
And your entitlement to
fees.
fees depend upon a reversal and a contingency reversal for you ultimately prevailing in the lawsuit.
Correct.
Okay.
All right, and insofar as the 57105 motion's concerned, which is the predicate upon which she's asking for fees in this case, I advance that this case, I mean, I'm making legitimate arguments here. This is not a frivolous case. This is not frivolous by any stretch of the imagination. And where they come up with this is, quite frankly, insulting. But that being said, I want to direct the court's attention to the definition of settlement closing in the whereas clauses of the original agreement, which was not amended. Settlement closing is addressed in the 6th whereas clause, and it states, whereas escrow agent has been retained to act as escrow agent for a transaction or series of transactions, open quote, the quote, settlement closing, quote, close paren, I'm sorry, related to the settlement of certain matters alleged by and between Trinity South Capital and Kennedy Funding, Inc. in that certain consolidated lawsuit pending in the state of Florida Circuit Court in and for the 6th Judicial Circuit styled Trinity Town Center LLP versus Course Labs Structures Tampa, Inc., and provides the case number and identifies that as the consolidated action. if you look at paragraph 2, or paragraph, paragraph 2 of the agreement, the contingency that is provided in there indicates that the performance and obligations of the parties under the escrow agreement are expressly conditioned, unconditionally contingent upon the settlement closing. Well, if in fact the obligations that run to Heavenly Air are contingent upon whether the consolidated action is settled, and the funds from that come from the construction loan proceeds, then the question would be, why isn't this agreement related to that, and why would it not be included within the scope of the term settlement closing?
Just to give you a warning, you're down to a half a minute.
Okay.
Make your last.
I respectfully request that the court reverse the ruling of the trial court in this matter, and that it deny the request for fees based on 57-105. Thank you.
All right, thank you very much, both sides.